Hi folks, in this video I'm going to do something I almost never do. I'm going to respond to some internet bull chatter. So I'm going to start with a recitation of facts. So this is stuff I can document. Last Monday, May 18th, during an ordinance committee meeting, whilst discussing the legal ramifications of the word repeal, Councilor Maggie McKee disclosed that she had sought legal advice from a private attorney regarding municipal law issues. She stated that she hired the attorney herself and paid for that advice with her own money. During this discussion, City Solicitor Jim Timmins raised concerns that consulting with an attorney outside the body could present open meeting law issues.
And maybe it would take the salary to zero. I hired my own municipal lawyer who has looked at things and made the amendments in the current versions of the council's repeal and the annual salary repeal.
First of all, if you're consulting with someone outside the body, and you don't identify who that is, you don't provide what their input is, that's a violation of the open meeting law, because you are accepting information that's influencing how you're acting. So what I suggest is you put your attorney in touch with me and we'll talk. I don't know if the attorney you're talking to is a municipal lawyer or not, but I'm happy to talk to him or her. And then
the following day, Solicitor Timmins began emailing Councilor McKee seeking the identity of the attorney. Councilor McKee declined to identify said attorney. According to the emails, Solicitor Timmins continued to express what he described as serious open meeting law concerns and indicated that he intended to raise the matter when it came before the council, and he was going to bring up their email chain as well. Now at this point, some of you may be asking, Joe, how do you know what was said between Councilor McKee and the city solicitor on email? Fair question. I know because those emails have now become public and were published online. People can read them for themselves. According to the founder and moderator of the It Begins in Quincy ... Facebook page, Leah DeGloria, she put in a records request for these emails, and it sounds like other emails as well. After those emails circulated, several open meeting law complaints were filed. So I went and I read them. If anyone else wants to read them, they're on this week's City Council agenda for June 1st. Here's what I found. One complaint requests the identity of the attorney, information about compensation and correspondence. Another seeks penalties against Councilor McKee. Another repeatedly references things that may have occurred but does not identify specific communications. What I did not find was a complaint identifying a specific communication between Councilor McKee and another councilor. I did not find a complaint identifying a quorum. I did not find a complaint identifying a secret meeting. I did not find a complaint identifying a serial communication. The complaints focus heavily on the existence and identity of the attorney. The complaints also repeatedly reference concerns raised by the city solicitor. And because I know how much Solicitor Timmins likes when people check his work and get second opinions, I reached out to the Mass Open Meeting Law Help Desk, which is an assistant attorney general who answers questions over email about or phone about the open meeting law so that people can stay compliant. So let's look. So I start off asking this question. Hello, would a single city councilor consulting independent counsel without communicating with other members constitute a deliberation by OML standards? In other words, can a city councilor consult with a private counsel about procedure without being considered a violation of the open meeting law? In this scenario, the attorney would have no contact with any other counselors, no serial communication, etc. From what I read on your very good resources, I believe it is not a violation, but I could not find this exact question addressed. Thank you. And not long after, less than an hour later, Assistant Attorney General Matt Lindberg writes back. Good morning. Thank you for contacting the Division of Open Government. Through this helpline, we can provide general guidance regarding the open meeting law. We cannot provide an advisory opinion or legal advice. The open meeting law applies to meetings of public bodies, which by definition must involve a quorum of the public body. If fewer than a quorum of members of a public body gather to discuss business of the body, that gathering does not constitute a meeting under the open meeting law and is not subject to the requirements of the open meeting law. He gives me some places to look. Open meeting law determinations may be found at that address. The open meeting law does not address the legitimacy of any action taken by a subquorum, only the procedures that must be followed when a quorum is present. A single city councilor would constitute a subquorum. Please let me know if I have misunderstood your question. Now, to be extra safe, I wanted to confirm. So I wrote back, thank you, Mr. Lindberg. Your guidance is much appreciated, and I believe it answered my question. My understanding is that because a single city councilor constitutes a subquorum, a councilor consulting privately with independent counsel or other experts without communicating involving a quorum of the body, including through serial communications, would not constitute a meeting or deliberation under the open meeting law. If I have misstated or misunderstood anything, please let me know. I appreciate the clarification and the citations. And they wrote back, yes, your understanding is correct. Those are the facts as I understand them from the documents currently available. These are things I think I know. Now we will move on to things I know I think. Okay, so the first part was facts. Now the fun part. This part is opinion. Take it or leave it. Here's what jumps out. This entire controversy runs on one assumption, that because the city solicitor raised open meeting law concerns, that there must be a violation. But that's not how it works. An accusation isn't proof. A concern isn't a violation. After reading the complaints, I'm still asking the same basic questions. What part of the open meeting law did Councilor McKee violate, supposedly?
This is nothing.
Who deliberated with whom? What quorum are we talking about? Was there a secret meeting? Was there an executive session that there shouldn't have been? Were there serial communications? You know, these are the things that open meeting laws are concerned with. Right now, I'm seeing accusations without a mechanism. I don't see legitimate complaints. I see political wishes. Because disagreement isn't evidence. Suspicion isn't evidence. And accusations, still not evidence. The outrage, nevertheless, arrived immediately. The explanation never showed up, though. A counselor gets a second opinion. The solicitor raises concerns. Then complaints get filed. Social media explodes. Cartoons get made. Everybody's mad. And somehow along the way, the legal reasoning just exits the building. Because strip it down and here's what's left. A counselor asked another lawyer for advice. And unless there's a law against that, and no one has produced one thus far, there's nothing suspicious about that. Nothing nefarious. It's a second opinion. People do it all the time. I'm betting the mayor gets second, third, and fourth opinions all the time that we're not privy to. I hope so, because that's what I call doing your homework. So this fits into a pattern we've seen since this city council took their seats. When people don't like what they say or do, someone cries open meeting law violation. In a way, it makes sense because you can file a complaint with no evidence. It doesn't cost you anything. You don't need a lawyer or filing fees. You just fill out a form. But every frivolous complaint that they put forward takes time away from real complaints, from legitimate complaints. Something else is interesting too. What is this obsession with who the lawyer is? And why does that matter so much? This AI cartoon I'm going to bring up here might have said the quiet part out loud. It doesn't show an anonymous attorney. It shows former Quincy Mayor Bill Phelan. And that joke only works if you're supposed to believe he's the guy. From all the clues I've seen, he is not. Which means Quincy spent weeks chasing a ghost. But here's a more uncomfortable possibility. What if the lawyer really isn't the issue? What if the issue is just that someone dared to get another opinion? I mean, look at the pattern. Complaints about the attorney, emails about the attorney, public disclosure fixated on the attorney. Everyone wants the name. Why? Because it's not about who the lawyer is, really. It's about the fact that there is another lawyer. For years, legal advice in Quincy has basically come from one place. Now, a counselor is not taking the solicitor's word as gospel. That changes things. See, legal analysis is a type of political power. A second opinion redistributes it. And that's the only thread in the story that actually holds up. Because it's not about a quorum. It's not about deliberations or secret meetings. It's just about a competing legal opinion. The real violation that Solicitor Timmins is upset about is a loss of his status as the only legal opinion that counts in our city's government. Honestly, the strongest takeaway here might not be an argument against Councilor McKee. It might be an argument for independent legal counsel for the city council, what I call council. But the people in this situation that I'm most worried about aren't the politicians. They'll be fine. They signed up for this. Not really, but you get it. They know that criticism comes with the job. Sometimes it goes actually a lot of times it goes way too far. It's kind of gross at times, but the politicians are tough. They'll hang in there. I'm worried about the residents because everyone watching this is learning a lesson. Your emails can become ammunition. When you email your counselor, you're basically emailing that other Facebook page. Those emails are basically being forwarded right onto that person. So your emails become ammunition. Your concerns can become content for the bots and the bot handlers. And your messages get turned into a campaign. So let me ask you, would you email a counselor right now? Are you confident it will stay professional? Or are you wondering if what you email is going to show up in someone else's post next week on Facebook? Because when people stop talking to their government, everybody loses. And that's bad for transparency. That's bad for accountability, and it's bad for the city. In the end, that's the biggest loser here. It isn't Councilor McKee. It isn't Timmins. It isn't Bill Phelan. It's public trust.